What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. All right, I've got some court. You guys want to watch some court? I want to watch some court. Let's see. We're going to start out in Florida with Judge, it's Collier. I don't know. One of those. If he ever sees this, he probably won't, but I do apologize for butchering your name every single time I cover you. Anyways, um, yeah, we got a bunch of court geniuses tonight. We're gonna start off in Florida, then we got one out of Texas, and then we jump up to Michigan. That's what's on the docket this evening. Thank you guys for hanging out with me this evening, and I'm ready to go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Your Honor,
Yes, ma'am.
the plea that we just entered, there might be a mistake that we made.
Okay, Ms. Turner? Was it Ms. Turner? Okay.
Yes, Your Honor. I clearly tried to get Miss Mavis here to
All right,
file a
well,
motion.
one moment. Let me swear you in first.
Oh, okay,
All
sorry.
right, no problem.
Swear affirm the testimony given in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes,
All right, Mr. Kane, we were here on Tuesday, and at the time, Ms. Miller placed on the record that there's a plea offer from the state, and you indicated that you wanted to discharge Ms. Miller. And we set it
Yes,
for
ma'am.
today to
yes, sir.
you to tell me what's going on.
Well, I've clearly asked her several times to make a motion to suppress the evidence and stuff, and she acts like it doesn't matter. But that sales charge matters to me, sir. And I didn't do it, so I just can't see me taking something I didn't do. I can get more sworn statements to that fact too. It just because that particular day is the way the chart read it, my discovery, way it read was they sent someone to my house that day, and I was real busy and they had to come back. Well, they still weren't nothing at my house. I told them there wasn't gonna be nothing at my house. Some old boy that was around out there in the yard said he could help them out or something. I don't know. I was busy working on a truck. I didn't have time to do anything. And that's what my factual basis lays on. And I've asked her several times to come forth with that, do something to try to get this mess off of me for something I didn't do. So that's why I moved for.
All right, and you said there are sworn statements to the fact that you did not do this sale.
I can get the sworn statements, yes, sir.
Have you given
Miss Miller those names?
No, I haven't, but she hadn't asked me for me. She keeps getting me to try to take the plea.
All right, I can let you guys know. His accent's a little thick, and they do get more into the case. But right now, he is charged with sale of methamphetamine and possession of methamphetamine. Now, the sale of it sounded like they had a little sting operation to catch him. That's what it sounds like. I don't quite remember. This happened about a week and a half ago, so I think that's what happened. They'll get into it. Anyways, he's saying he didn't sell anything. The possession part, I don't think he denies that, but he doesn't really admit it either. But he's saying it wasn't me that sold it. There's video out there. I can get testimony from people saying that I didn't sell it, but they're saying there's video, and the prosecution is still charging him with the sale of it, and they have video. So it's, yeah, I mean, what do you? So that's what's going on. So this guy is trying to file a motion to suppress the evidence that he sold it because he didn't sell it, and his attorney is not filing the motion, so he's trying to get rid of his attorney. That's what's going on right now.
right, Ms. Miller,
Um,
as to the motion to suppress.
What we've spoken about, and I have in my notes, I printed them out from my meetings with Mr. Kane, and I'm gonna try and limit it to just what's needed to defend the
Yes.
motion, so I don't say too much, but I know that we had the office visit that was scheduled, and we met on October 22nd in my office. I think we spent over an hour talking about his case. His mother was present.
That wasn't my mother, that was my whole lady.
It was, I'm sorry, it was a female that seemed to say that she was his guardian or took care of him in some way, and he understood that even may have waived even attorney-client privilege with her being present. But she indicated that when he was younger, he indicated that he had been diagnosed with ADD. I told him to go ahead and go get prescribed medicine, because whatever the outcome, then we could make sure that you were getting the prescription if it ended up with him being in prison or on probation, he would be allowed to still continue being medicated in legal ways with legal and prescribed amphetamines. I explained to him that there was this control by and a controlled that he used a confidential informant that was used in that to create the basis for the sale. And based on what he was saying, that maybe there potentially could be that issue with.
What issue?
An issue with whether or not that the videos, if we were to get the video, might show somebody different. Maybe there is those things we just don't know because we don't have that at that moment in time. But we discussed that in order to get that material, Mr. Patterson was going to require that I, of course, do a motion and have the court order that information be compelled and disclosed to us. And I explained that if that happened, that the offers were off the table. So we wouldn't be able to see that video if we wanted to still continue to work on a negotiated resolution. But we could get that, but we just wouldn't be able to get it before without waiving our basically that ability to negotiate with the state at that point.
Whoa. How does that make sense? The state will only negotiate a plea deal with you before they give you discovery? That sounds like that does not sound right. I don't know. Maybe this is common practice. I don't know, but that does not sound right at all.
And what I explained was, even if there was a motion to suppress there, the officers, when they went and obtained the warrant and were serving the warrant for his arrest on that sale, were acting in good faith. So the amphetamine that was found on his person when he was arrested, that is the basis for the second charge, would still stand no matter what happens with the first charge. And that he's scoring prison on his score sheet based on the two charges, but it's unlikely that he's going to get something other than probation on the second charge based on his history, is what we had discussed. We discussed anything that was a non-prison sentence. He gave me permission to work for a 36-month probation offer. So I reached out to Mr. Patterson to discuss that. He seemed happy.
We are not jinxing that one bit. One bit. Do not jinx that, because I still have no idea. The technician that was here, he didn't know why it was happening. The only real response he gave me was, if the modem is causing it, then that's going to be fixed because they installed a new modem. But he couldn't tell me that the modem was causing that issue. So we'll see. Because internet speed has never been a problem, but my speed was fine. But the problem was I just have these random hiccups throughout the day where I just lose internet for no reason for about 5 minutes. Then it comes back up and it's fine. But my speed never seems to be an issue. I mean, I run 50 tabs of Chrome, most of the day. All right. Anyways, back to the case.
My notes say seemed happy if he could get that. Told him to be in court on Thursday in case a good offer came. And his odds of getting that offer might increase if he was actually present. Then I did speak with Mr. Patterson. And when we spoke to Mr. Patterson, he gave that offer. I said we met yesterday, but and this was at the note from the pretrial, because I met with Mr. Patterson the day before pretrial, but Mr. Patterson offered that 1 year of community control followed by the 24 months of probation, which is what's here. We conveyed that to the client. He explained then that he wanted more time to get his affairs in order. I had questioned what affairs, because it's not prison. And I was a little taken aback, because it was almost exactly what he said he would have been happy to receive from our previous hour-and-a-half long meeting. And then even at that time, he had just indicated he needed more time to get his affairs in order to accept this offer. And so obviously I'm not pushing to get anything, because we're still in the process of negotiating that. We did ask the court to pass the case. It was passed. And again, the second time he ended up indicating he had some questions about it at that point. And when we had set up some appointments, I attempted to call on November 20th. And I received a message, the person you called is unable to receive calls at this time.
This is the defense attorney. The defense attorney is sitting next to him. The prosecutor's actually at the table behind the defendant. In the little screen at the bottom left. You guys know the judge. The guy in the bottom right, he's a defense attorney for the next case, which I am playing as well.
We ended up coming to court, I think, and then passing it again, so we would have that opportunity to talk. I do know that at some point I did explain to him again. I showed that on 1/6 that he was set for tomorrow. I have an email to Mr. Patterson, and I showed that he ended up, I'd emailed him on January 6th. I then had a phone call with Mr. Kane on the 6th. I believe that the email might have been in relation, it may have even come after that. But again, we had the same conversation that we had on October, which was that I explained that the meth in his pocket when they served the first arrest warrant wasn't going away. He then explained that the officer took the syringe, squirted its contents into a vial. I think he was trying to had questions about whether or not there was still sufficient amount to do secondary testing. I don't know that I have a reason to request secondary testing. I don't have any basis, I think, to question the FDLE results, but it was sufficient. It came back as a methamphetamine. There are photos of the syringe that he indicated. Again, he was speaking about the other case, but to me, it's the issues on the suppression. Yes, we can get the CI video. Yes, we could then maybe, if there's a basis for a suppression motion, maybe file one at that point, if one exists. But then at that point, all offers are off the table. And so, again.
And as to the, he said there are sworn statements that he didn't do the sale.
I've never received any names of people that would be able to say that it was someone else or that it wasn't him. I don't have any alibi information to confirm or to convey. But even on this court date, on that telephone call, Mr. Kane asked that I counter and ask for that 36 months of drug offender probation without the community control again. So then I'm still negotiating. So then I emailed Mr. Patterson. I did ask for that. He's set for tomorrow. I was in the conference with him now. I asked for that, and Mr. Patterson's response to that request again was, how about the 15 months in DOC he actually scores? And then I asked Mr. Patterson, well, is this offer still here? And he indicated, yes, the 1 year followed by the 24 months of community control are still here. And that was what brought us up to date. So we were still negotiating up to January.
Yeah, I think it's a little much. She's going into way more detail than the court asked, but she's being called out. The defendant saying she's not doing what he wants, and she's probably like, screw this guy. I'm gonna walk through everything I've done, and it's a lot.
6th of this year.
Mr. King.
Yes, sir.
Anything else? What evidence are you trying to suppress?
Well, the fact that they just set me up, Your Honor. I mean, I didn't sell no methamphetamine. I did not sell any. I mean, it's just natural act basis. I was too busy working to do anything.
Okay.
So, I mean,
You have a right to a jury trial as to the Nelson here, and I haven't heard anything that Ms. Miller is rendering ineffective assistance of counsel, so I'll deny your motion to discharge Ms. Miller. I'll advise you that if you do not want Ms. Miller to represent you, the court will not appoint another attorney to represent you. You can represent yourself or you can hire someone.
yes.
All right? It sounds to me as though you don't like the plea offer. And
No, sir, for something I didn't do, I don't like it.
that's why we have juries. So
Okay.
if you want to reject the state's offer, get the video of the cell, and we'll go to trial.
What's kind of funny about this court is their cameras, instead of actually figuring out how to set up their Zoom so they just share the screen of what's going on, they have the camera on a TV in the courtroom. Sometimes you just can't make this stuff up, but that's how they do it. And then, the top right, I don't know who that's supposed to be. Maybe they're waiting for BSBT to show up in Florida as well. That's his seat. Who knows?
All right.
Is that what you want to do?
Yes, sir. I guess so. I mean, I hate to take something for something I didn't do.
I understand. You understand that the state's offer was a downward departure, that your minimum on the score sheet is 15 months in Department of Corrections, and the maximum that you are facing is 20 years in prison. You have a second-degree felony for sale of methamphetamine. You have possession of methamphetamine. That's 15 years for the sale, 5 years for the possession. That's 20 years total that I can sentence you to. And the state's offering you 1 year community control followed by probation. You understand that? Mr. Kane?
Yes, sir.
You understand that I can sentence you up to 20 years in prison if you're found guilty as charged?
It's a long time. I'd be dead if I got out of there.
I'm just trying to understand, make sure you understand that you are what you're getting into when you reject the state's offer, and it's completely your decision to do so. I'm not pressuring you. You don't want to take the offer, don't take the offer, but I don't want to be in a situation where you exercise your right to a trial by jury and they convict you as charged, and we're sitting at a sentencing hearing and you are saying that you want probation. And I won't sentence you to probation because that's what the state offered you. I wanted you to be aware that I can sentence you up to 20 years in prison.
Never did nothing bad. Good God.
Ask for time to think about it. There's no shame in that. That's a huge decision, especially if he didn't do it, right? He knows if he did it or not. And if he absolutely didn't do it, no, don't take a deal. They have camera footage of the cell. If that wasn't you, then it's easy to prove that it wasn't you. Don't take the deal. The hesitation, though, is what's a little tricky here. He doesn't just absolutely say no. He's like, I don't. I mean, 1 year to 20 years though. So there's, I guess I can kind of understand, but still, it should be yes or no. Was it you or was it not you?
I just need to know whether or not or you understand that that's the statutory maximum. Do you understand that?
Yes, sir.
Is it your decision to reject the state's plea offer of, 1 year community control followed by 2 years probation?
Yes, with the base, if he's convicted as charged by a jury, when juries can be unpredictable, and if he is convicted of everything, of course, that the lowest that he will receive is that 15 months of prison. The maximum is 20 years.
That's the lowest you can. Of course, I look at the score sheet. I listen to what your attorney will tell me. I listen to what you, the family, what the state. That's the minimum is 15 months. I'm not a minimum type guy. But my question to you is this: is it your decision to reject the state's plea offer of probation?
Yeah, if he would let me have Doug Pender 3 years probation and not the community control, because I just don't know if I could do community control.
I don't negotiate pleas. I just need to know, is it your decision to reject the offer, or do you need more time to think about it?
I need more time to think about it, maybe till next month, if he would extend that courtesy to me and let me just think this over. It's a big deal. take something for something I know I didn't do.
I definitely understand that. It's a risk you're taking if you didn't do it. That's why we have a jury. But you never know what a jury's gonna come back with. And in Gulf County, I've been surprised. They found people not guilty that I thought the evidence was sufficient. They found people guilty when the evidence was towing the line.
You know, I used to. I had playlists for a lot of my cases, especially when I followed people. I deleted them all. I think I deleted them all for a reason, and I meant to put them back up because I think it got messy. I didn't know what I was doing when I first started it, and I don't think I set them back up again. I don't know. I'll check that tonight though. I need to have them if I don't.
Mr. Patterson, you'll leave the plea offer open?
To our March 4th date, Your Honor.
All right, we'll come back March 4th at 1:34 pretrial and say leave its offer open until then.
Thank you, sir.
Do you want a sidebar on Mr.
And we have Mr. Davis. Mr. Davis, good morning to you, sir.
All right. I need to give a little prep before this next guy. I covered his first case, and it was about 2 months ago. And I went back to try to find it so I can link it in the description. It must have been in one of my random lives where I just throw a bunch of clips together because I couldn't find it. I know it's there, so I remember him. He is the defendant that was arguing the points that he was getting for his crime, the scale or I don't know, the point sheet. You know, one crime equals this points, whatever, and that you get sentenced based on the points. And he was saying that because he was married, he can't be charged with the level of assault that he was charged with because he did something to his wife or his girlfriend, something like that. No, it's because he was living with them. He's like, you can't charge me with that because I'm living with her, or something like that. It was something dumb. And the attorney just kept saying, like, that's not a thing. Stop. And then the guy's just like, okay, well, I'm gonna go without you because you don't know. I've been reading all these law books. So he fired his attorney. Well, I guess he didn't fire him. He asked to represent himself. And I guess the judge didn't accept his motion to release his counsel because he's here. And this is hilarious. This guy's had no counsel for 2 months, and he changes a little bit.
We saw you in a while. We're here in case number 24 CF 42 and 24 CF 59. I see that there are a couple motions you filed, and Mr. Williams is here. As you recall, I appointed him as standby counsel. You still want to exercise your right to represent yourself?
I can't, because I can't represent myself. I know that.
Okay. And I was going to bring that up to you. I saw that I review everything you file in the court file. Now, one of the things that you placed in the bottom was I'm representing myself, which I know I'm not fit to do, but I don't want Mr. Williams to represent me. And I know we've already gone back and forth about your issues with Mr. Williams. Well, what's the plea offer in this case?
Your Honor, we
Mr.
never
Well,
really
what I'm
had
gonna do, one moment, Mr. Williams. Mr. Davis has indicated in writing that he's not fit to represent himself. He's told me here in court that he knows it's not a good idea. So I'm going to appoint you to represent Mr. Davis as of now. We're going to see what goes on today.
Very well,
what was
Your
the
Honor.
Mr. Williams? Go ahead. What was the plea offer? I don't recall.
I was going to say, Your Honor, we never had a formal written plea offer. If Your Honor will recall, there was a little bit of confusion with regard to the initial score sheet that was filed or filled out by the state. And I met with Mr. Davis, and there were some things on the score sheet that he said, were a mistake. I got with the state, and they did some checking, and I did some checking, and there were a couple of things that were on that score sheet that shouldn't have been on that score sheet, and it resulted in reducing his lowest permissible sentence down a year or so. But at that point, then I was taken off the case, so I didn't continue pursuing, you know, a formal offer from the state.
Okay. And is the relationship, Mr. Williams, with you and Mr. Davis still the same as it was before?
Well, I haven't had any contact with Mr. Davis, you know, since I was relieved as his active representation.
Yes,
so I
Mr.
can
Davis,
just
you still feel the same, Mr. Davis, about Mr. Williams?
No.
Mr. Davis says he does not, he no longer feels the same way, Mr. Williams.
I've been my own attorney for 2 months. I cannot do this. Mr. Williams, I take back everything I said about you. You were awesome, man. Please come back. Good for him, though. He tried it. Nope, not for me. Can't do it. Good for him.
So I know there are some motions for discovery, and Mr. Williams should have all of your discovery. Mr. Williams, have you provided Mr. Davis the discovery?
I don't believe I had the opportunity to do that. I was in the process of after I met with Mr. Davis and he wanted the discovery, and then before I had a chance to meet with him again, I was relieved. But I'm happy to set up another meeting with him and to bring the discovery, go over it with him. I'll bring a copy for him that he can have and keep there in the jail if that's what he'd like.
Do you have the medical records? I know this is felony battery based on serious bodily injury, and some of the motions that were filed were directed toward medical records. Do we have any medical records, Mr. Patterson?
I have an entire folder full of medical records, Your Honor.
Okay, Mr. Williams, do you have the alleged victim's medical records?
I do not have those, Your Honor. I have a sort of a summary report of the doctor that examined the alleged victim, you know, on the date in question, but I don't have the entire medical records. I'm happy to get with Mr. Patterson and get those from him.
All right, so Mr. Davis, that was one of the issues you raised in some of your motions. The state does have a folder there. Looks like maybe an inch thick of medical records. They'll provide those to Mr. Williams and he'll get you those medical records. Anything else?
Sir.
Okay.
Your Honor, I found two different score sheets in the file. One showed a lowest permissible of 68.25. The other score sheet shows a lowest permissible of 56.1. So I assume those are where the corrections were made to the score sheet.
So Mr. Davis was right initially when he was talking about the score sheet being wrong. So they've corrected the score sheet and it's now the lowest permissible 56.1.
Yes, Your Honor.
All right,
That's
and
correct.
the relationship, and Mr. Davis says he's perfectly fine with Mr. Williams representing him, and he no longer wants to represent himself. We have those, the state has those medical records. They'll get those to your attorney and you'll have those medical records to review. We're not set for trial, are we?
Yes, Your Honor.
We were, Your Honor, for the 24th of this month, but I would request that in light of the development today that we set it for your next pretrial. I believe you said it was March the 4th.
Have you all deposed the victim? Has anyone deposed the victim yet?
I have not deposed the victim, Your Honor.
In what case would you want to go to trial on, Mr. Patterson?
The victim case, Your Honor, the felony battery case. And I
Okay.
know the court's
That's
aware.
for, that'll be
The time that I've been
24/42.
here, Your Honor, there's just been this back and forth about who's going to represent Mr. Davis. Is he going to represent himself? And now I think it's just a situation where that ball got kicked back and forth, and I don't think it can be ready. I didn't know who to negotiate with, didn't know who to send things to, so.
No, I agree with you. This is felony battery based on priors. The defense doesn't have all the medical records. They haven't deposed the victim, so I'll grant that continuance, and we'll see you back here March 4th at 1:30. That'll give you an opportunity to take the victim's deposition, review our medical records, and get prepared for trial, Mr. Davis.
And I'll get with the state forthwith, Your Honor, and get those matters set up. And at least we'll be able,
All right, then.
we may not be able to have a total answer on March the 4th, but we'll at least give you a progress report.
Okay, and let's at least have the deposition set before March the 4th and make sure that Mr. Davis has the medical records and discovery.
Absolutely, Your Honor.
All right, thank you. Mr. Davis, take care. Yes, sir.
Can you please bring a copy of the score sheet, please, so I can review it?
Yeah, I'll be happy to do that, Mr. Davis, as well as all the other discovery, as I mentioned earlier.
All right, thank you.
Thank you, Your Honor. That's the only matter I have before you, so with your
All right,
permission. I'll
Mr.
take my leave.
Davis, before you walk out.
All right. Wixom, I like him too. He's one of my favorite judges to watch. He only streams like 1 or 2 days a week, but every other week. It's kind of weird. So I don't know what his calendar's like. So he didn't stream this week, so he'll probably stream a couple times next week. All right. Next one. Oh, next one we're going to Texas. This is a this one is this one might give you a headache. I can't tell if the I don't want to call her the defendant because it's a civil case, so she's not a defendant. But I can't tell if she's being ignorant on purpose or if she's just made it to the age of I don't know. I'm gonna say 55, 60, and she's just absolutely clueless on how things work. Yeah, yeah.
You're helping my mom. She has a bit of a hearing trouble.
Okay, all right.
Thank you.
Tell me why we're here.
Ms. Campos was involved in an accident on June 13th of 2024. Ms. Campos changed lanes on the interstate, crashing into another vehicle and guardrail. The damages were estimated at $10,648.53. Her license is going to expire on January 18th of 2031.
All right. Have you worked something out, some type of installment agreement, Ms. Campos?
No, what is that for? I thought I was here to show that I had insurance at the time.
Well, did you have insurance?
Because DPS is saying I wasn't covered. So I brought proof that I was covered the day of the accident.
Right, well, have you provided that proof to the other insurance company or the other party?
Right, that.
I have it here that I was covered at
No,
the
that's
time.
not what I'm asking. What I'm asking is, did you provide that insurance information to the other party so that they can file a claim against your insurance policy?
No, I showed it to the officer.
It was
Yeah, I think this looks like Patton Oswalt when he hit 70, 75. That's what he reminds me of.
provided at the time of the accident to show that we did.
Have you gotten letters from the other party for claiming damages?
I believe it was only the letter for setting up this hearing.
You've never gotten any letters from the other party that they're seeking you to reimburse them for anything that they have paid?
Why would I reimburse them?
Your insurance company to reimburse that other party because your insurance company insures you.
And her insurance company sent a letter to the other person's insurance stating that there was no insurance coverage for her. It's right here, the letter.
Well, that's where it's wrong because I have proof here that I did have insurance, that my insurance company, that my original insurance at the time canceled me.
So you have to submit that
It
to
does
the
show.
insurance company of the person that you crashed.
Why do I have to show it to her? She has,
Not
The
to her,
right-
to her insurance company.
well, did they request for that? Or they send me a notice saying that they weren't gonna cover me.
I believe we assumed that the insurance company would communicate with their insurance company. They
Oh,
did.
you just said your insurance company was not gonna cover you.
Well, that's fine, as long as they cover her.
No, I just thought you said that your insurance company was not gonna cover you for that accident.
No, my insurance, I'm assuming my insurance company paid for me and her insurance company paid for her.
No.
Okay, I thought that's how it works.
No, it doesn't.
So that's why you have insurance coverage.
Yeah, no. The purpose of having liability insurance is that if a person is driving and they're negligent in operation of the vehicle and cause an accident, then the other party can seek reimbursement from your insurance company. That's why you pay insurance.
Oh, like an additional amount on top of.
No, not additional amount. There are different kinds of insurance. There's property insurance that protects you on a new car in case you hit a guardrail or something. You pay a deductible and they fix the car. That's the difference between that and liability insurance. Liability insurance protects you from you being negligent.
It is full coverage insurance because the car was still,
All right, okay, well, what she should have done at the time, when she had the accident, was full coverage, is call her insurance company and said, I've been in an accident, here's the information on the other party.
And I
we
did,
did.
and I did.
They sent us a check they did.
They sent you a check for your damages.
Yeah.
I see.
Okay,
Would it-
why,
I'm not worried about your damages. The issue here is that there's been a determination that you were negligent. Let me see the accident report.
I feel I wasn't negligent.
He had to stand up because he had to get the blood running through his body. Otherwise, he would have got a headache from listening to this. This is insane. And this is why I put on the thumbnail. That's not how this works. That's not how any of this works. Ah, lady, your son's there. Are you both this clueless?
So why should I pay anything? Huh?
We'll see what the insurance, right?
And then I didn't get a police report showing.
Well, they don't give you police reports. You have to request them.
No, when the officer was there, he didn't take my statement.
Then I also have here the letter from the insurance saying that she was not covered.
May I see the letter that they had sent to the insurance?
Yeah, sure. Show
I
him
brought
the
the letter
letter.
that shows that I was.
Thank you. I don't understand.
Was your insurance like the other insurance?
Go back there.
Probably Apollo.
So, is to pay. If they find her at fault, then her insurance is supposed to pay them for their damages. But I guess according to this, it's not either not covered or.
Well, that's wrong because I pay my insurance payment every month. Every month I pay my insurance. And I think the insurance I had at the time, they canceled me and I end up getting a different insurance that I recently found out. But it doesn't matter. Every month I was paying my insurance. And I don't feel I was negligent either because I signaled. And when I spoke with her, she saw me that I signaled, and she was also.
All right, stop, lady, stop. Doesn't matter. It doesn't matter now. The police report says that you're at fault. That's where this all stems from. Is that day. Judge can't do anything about that. Even if you're 100% right now, the judge can't touch that.
At a safe distance that I can get in her lane.
Let me see the letter from the insurance company.
It says on there Mike Kramer, but there was only one female that was driving the car. Full coverage, they would take care of that. And then we do have the document that does show the amount of bodily and property damage.
We are working. We might do something special on Saturday night for date night, but tomorrow is just a regular work day for us.
Damage. The only thing that may have not been covered is if they were uninsured. But we're not aware that we needed to reach out to their insurance. We usually believe that.
Me?
Yeah, we're supposed to reach out to their insurance.
They called me. They called her insurance called me for a statement. And mine's too.
It does say on that Mike, a guy's name.
Yeah, this is the if I understand what this hearing's about is the person that got hit is suing her, the driver, for the money because she wasn't covered. That's what I think this hearing's about. If I'm wrong on that, if this is actually a whole traffic issue, then yeah, I apologize. I am wrong. But I think this is just a small claims matter for the 10,000 that they said at the beginning.
Who is that?
Maybe the father or
She herself.
I don't know if maybe they tried to file it under him. Or
All right, well, this is what I'm gonna do. I'm gonna reset this. I'm gonna reset it 60 days, straighten it out with the insurance company. You need to reach out with that to the insurance company.
What is it I need to do?
I'll let you know when we found. Does it mention what, I think, on their insurance policy or their company that's on there?
Yes?
It has
Yeah, AAA. It was AAA.
Yes.
insurance exchange of, triple. Okay. We'll reach out to them. Once we reach out to them and receive their information, do we send it to the email or?
Well, I mean, if your insurance company was, if she was in fact insured liability on the date of that accident, then her insurance company should,
Cover her.
well, cover you, not cover her, cover you so that whatever they agreed to as to what the damages are.
Well, it did cover me to replace my car. No?
It didn't cover,
I'm not going over there. No, I'm not going over that anymore.
Well, it's my first experience.
That's not how it works. I'm not gonna go in there because I'm gonna,
we'll reach out to the insurance. and I'll
yes,
try
do
and help
that.
with the,
All right, that's it. Anything else?
How many reset? 60 days, is it?
Yes, 60 days. Were you here? Do you have something? Jones? All right.
We'll receive in the mail,
Yes, we're gonna receive for the reset.
So you
Thank
have
you.
60 days to work it out.
all right, thank you.
Is that it?
And then bring whatever documentation.
Okay, to that one. All right, thank you.
So is that it?
Yeah.
Is that your first time?
Yeah, we got it.
All right.
All right. All right. Let's move on from that. Oh, before I go any further, real quick, Wendy, thank you so much for the super chat. Colin, I just wanted to say hi. I really enjoy your lives. Thank you so much. I appreciate that you enjoy them. Thank you for hanging out and thank you so much for the super chat, Wendy. That is awesome. Also, Wixom, what the fuck? Incredibly generous PayPal. I appreciate it, man. And I absolutely will. I absolutely will. I will do something extraordinarily nice for Heather on Saturday night. Or wait till the next time she visits and take her out to a restaurant for her birthday, her favorite restaurant for her birthday. That's not till May though, so got a little bit. I don't know if I can save on to that till then. Anyways, Wixom, that is awesome. Thank you so much. I appreciate it. Sparkle Poots, 13 months. Thank you so much, Sparkle Poots. All right, now we're moving to Judge Simmons. We have a landlord tenant case, and I'm going to be honest with you. I have not seen part 2 of this. I saw part 1 and just instantly cut it and threw it in tonight's live because part 1 is hilarious. So part 2 has to be equally as good. That's my logic. So if part 2 sucks, I'm sorry, but part 1 is funny. Heather's favorite restaurant in Cincinnati is Soto. It's called Soto, Sotto. It is downtown. It's actually a really cool spot. I don't really know how to explain it. It's an Italian restaurant, but generally we go there when she visits. We haven't been there the last 2 times she visited though. But yeah, Soto. It's amazing. Peter, member for 4 months. Thank you so much, Peter. I appreciate it. And I appreciate it that you're here. And yeah, you guys are awesome. Thank you guys so much. Yes, Wixom is correct. This is Lansing. All right. Now on to this weirdo. Okay, let's go. Wixom, you're awesome, man.
Okay, Oak Sparrow Properties and Sandy Property Management versus Chase Carson and Amanda Williams. What's your name?
Chase Carson, Your Honor.
What's your name?
Amanda Williams.
Oh, that's it for me. Council appearance.
Good afternoon, Your Honor. Jessica Larson on behalf of Plaintiff Oak Sparrow, along with representative of the property.
Okay, today was the date set for hearing. This is for termination of tenancy. Did the parties come to a resolution?
I think a lot of the hate for the personal injury attorneys comes from the term ambulance chasers. The ones, yeah, those ones are annoying. But not everyone's like that. Yeah, but yeah, I understand what you're saying. That they would have helped her out a lot.
We haven't spoken on this one, Your Honor. From the prior hearing, my understanding is we've got quite a dispute. I don't think that we're in dispute on possession. The tenants are indicating that they actually vacated far before we believe that they did. So I don't know. I don't think that a resolution is likely on this one, Your Honor. I do say that I will say the issue of possession is probably moot because the tenants are indicating you moved out.
I don't know what prior hearing you're talking about. I have a note here, let's see. To breach trial, present, then it's no longer in possession of property. There was a hearing for the 18th. Okay, so what happened? You're saying you vacated the property?
Yes, Your Honor. I was served a 7-day 24th. I'm new to this whole process. I've always paid all my bills. So at that point, I uprooted everything that I could take, including my family, and we vacated the property. I attempted to make a phone call to Miss Sandy Bristol, fell upon deaf ears, as many communications had to that point. I, at that point, thought this was all behind us, and then all of a
Communication
sudden,
saying that you had vacated. Is that what you mean?
yes, I attempted
Okay.
to contact her and let her know the key was on the counter, and we were out of there.
Well, it happened. New router did not fix it. New modem, nothing. Nothing. So you know what that means. It's gonna happen again. So frustrating. Legal fiction. You're not frustrating. You're awesome. Thank you so much for the 13 months. I do appreciate it. That is awesome. Hopefully you guys can still hear me. Aliens. Yes, aliens. Aliens. I'm not gonna hit the play button for a minute, guys. Yes. Stronger than yesterday. Sparkle Poots. All right, all right. Yeah, I'm gonna wait a second. Generally, this it happens because up and down for a few minutes. So I'm gonna wait. Yeah, it's looks like it's bouncing back up. Wow. No.
I did text her and ask her why.
Yeah, right when I hit the play button, it froze. All right, but I'm gonna play it. Let's see.
On the day of the that I received the 7-day, because at that point it was to my knowledge we were doing everything that we could to stay in the property because
Oh, you know what's happening? Remember the guy that I covered from Judge Simmons' court? That his neighbors were attacking him with microwaves? I think that's happening to me. My neighbors are absolutely attacking me with microwaves every night at the exact same time. Man, I think he was claiming attempted murder, right? Can I claim that? Um, that's actually a good question. I got to go back and look. He keeps pushing things back because I know why. I'm not going to explain why, but he has good reasons for pushing the videos back. We were actually supposed to go live on his channel yet last night, but he had to push it back. And sometime soon, it's coming up sometime soon. It's within a week. I'm going to be on his channel. But yeah, the next time I'm with him, I'll be live on his channel. He won't be on mine. Let's see, Peter. Funny to get the gremlins out of his router. Thank you, I appreciate it. I got a new one today. I did. I upgraded my internet today. Did not fix the problem, but it seems to be a little bit less tonight. It seems to be it bounced back really quickly. So it's not the router that's the issue. We need to figure this out, or you guys don't. I need to figure this out because this is ridiculous. It's now been, I think, what, 2 weeks now? That's every single night it's happened. All right, I'm gonna stop yapping. Let's get back to the case.
we had previously had a case due over our animal that they tried to evict us and they lost in court. But for whatever reason, that still shows up on our record. So when we attempted to go get a new home, when they refused to renew our lease, we have a red flag. I can't rent anything. They won't even show me places. So I reached out to Miss Bristol, and in good faith, I said, I will do whatever it is in my power to keep my family in this home. I jumped through their hoops. I gave them record of my dogs. I obtained insurance. They
I'm talking
walked
about
the
this
property.
eviction though?
What's that?
I'm talking about this eviction, not the previous one.
Yes.
Okay,
Yes, so, I'm sorry, I guess I misunderstood.
okay, because I thought you were talking about there was another eviction
There
about
was
an
an
animal.
attempt at it.
Okay.
They were ruled against in the
Okay.
courtroom.
So since receiving
that
this notice
eviction
of
has put-
eviction, that's when you reached
Yeah,
out and
that-
said you would do anything?
Yes, after when I attempted to, because then we went back and finished out our lease, and then we got a letter in the mail that they are choosing not to renew. So I was like, that makes sense. And I attempted to find a place. When I realized we were blacklisted and I couldn't even rent a place, then I reached out to them and said, I'm willing to do anything that you would like. And I did everything they like. They walked the property. Everything looked good. There was no damage to the property. And then all of a sudden, the letter comes in the mail, you need to leave within 7 days. So in fear of another thing going on my record, I took what we could and we vacated there. We were gone before June.
When you say you took what you could, doesn't sound like you took all your stuff.
No, ma'am. No, ma'am.
Then you didn't turn over possession.
Like I said,
What did you leave there?
I just things that we didn't have space to store or anything. I took the possessions, our day-to-day possessions, and we bounced around since. We were going to make an attempt to clean the place up if that was their request, but again, she did not give me any communication back and forth until we got a new court date.
So you
After
communicated
that-
with her in via text after you left?
Yes, I asked
what
her
did you
on the
say?
24th. I said, why? And she says, you have continued to ignore us. You never submitted the animal application and the dogs were an issue. It's too much of a liability.
Did you
Well,
tell her
I
that you
do have-
vacated? Did you tell her that you vacated?
No, because I hadn't at that point. This was the day
Okay,
that I
I wanna
received
know
the
what,
7 days.
I wanna know about you communicating that you vacated.
That was a telephone call.
Okay, you called her?
I don't have a record of the telephone
Did
call.
you
It's
talk to her on
logged
the
up.
phone or did she not answer?
No answer.
Did you leave a voicemail?
I was not able to leave a voicemail.
Why not?
I don't use Wi-Fi when I stream. I use Wi-Fi for everything else, but when I'm doing anything that has to do with my channel, I am not on the Wi-Fi. So just to let you guys know that yeah.
To be honest, I don't know if her mailbox was full or what have you, but I wasn't able to leave her a message at that time.
Okay, so how was she supposed to know that you vacated?
Answer the call.
Okay, so when you called, let's say she was tied up and busy, couldn't answer. Or maybe technology didn't work well, and she didn't even know you called.
I don't know how to answer that for you. It was a confusing, scary time for me. I have not experienced things like this. I just like I put my hands in there. We're out of here. Like I've done everything I
And
can.
you
do to
left the
stay
keys
here.
there, you said
Yes.
at the property? Okay, counsel?
I'm sorry, Your Honor.
Counsel, did the property appear to have been vacated, but there was a number of things left there?
There was a substantial amount of things there left, Your Honor. From my understanding, the tenants continued to reside there because they were paying utilities there. And so the date of the hearing that I think Your Honor read, that was in front of Judge Buchanan. My client didn't get notice of the utility switch over. There was no indication of keys being left. There was no written notification. There was no verbal notification. Up until that hearing, we had no idea that they were going to even claim that they had moved out back in May.
Where were you still paying?
Well, we had past due amounts, so I was paying the minimums at that time to keep my name from getting to the point where I wouldn't be able to put utilities in my room at the next, or I mean, my name at the next residence that we would be at.
My client didn't get notification of any utility turnover until, again, after the hearing that was before Judge Buchanan back in November.
Which all would have been communicated had her client answered the phone call, but she put me
Well,
on
you
silent. do
You
not
didn't change the
disturb.
utilities over to your new place. Where did you, when you
I
left? where you
can't
moved?
find a new place because. of
Okay, so
this
you don't have a new
No,
place?
I'm bouncing around, staying with my mother at the moment.
Okay.
This has created quite a
But,
situation.
but
for us.
you didn't disconnect the utilities at the place, you just was paying about, you have some evidence of the utility bill?
No, I don't have evidence of the utility bill.
Do you have any evidence of what was left in the property?
I have a ton of videos and photographs, Your Honor. My client has also gone by the property several times and can indicate that the vehicle that Mr. Carson and Ms. Williams, that vehicle was outside of that property on many occasions when she was driven by. There's a ton of
Yeah.
stuff outside of the property. There was absolutely no indication that these parties had vacated. There's shoes on the porch.
Show your
there's-
evidence.
And Your Honor, I will say too that the client.
Was there any physical evidence of us being there or a picture of my vehicle there? Because I can guarantee that wasn't the case. They
And I can-
park
Okay.
in the driveway next door.
Okay.
So
Well, how would you know where my client parked?
Where are you, if you all want to talk,
They
off the
didn't
record,
park
off the record, bye. You can talk outside. If you want to talk to each other. If you want me to handle it, then you talk to me. You can talk outside. Next case. On the record, in the matter of the people, I'm sorry, a matter of 421 Seymour LLC versus George O'Dellin, 24-08615.
Thank you. Good afternoon, Sam Joy.
All right. That is all I've seen of this case. And that was enough to put this in here. We still have about 15, 20 minutes left, and I'm excited to see what happens here. I did when I was editing it though, I saw the last 30 seconds of it. And let's just say Judge Simmons is yelling at the dude at the very end. So it's gonna get good.
Okay, back on the record, counsel. And this is Oak Sparrow versus Carson and Williams.
Thank you, Your Honor.
And you've not come to resolution, correct?
We have not. It sounds like we're at an impasse, Your Honor.
Okay, so then you need to talk to me and not to each other. Back and forth is not gonna be allowed. If you start back and forth, I gotta move on. Look, all these people behind you waiting for their turn.
Apologies, Your Honor.
Okay, I'll allow you to present your evidence.
At this point, Your Honor, it sounds like based on some of the claims that the tenants are going to make as far as the utilities and how those were paid, I'm not able to access that. My client is not able to access a record that is in the tenant's name without a subpoena. So I'd ask the court to allow me to issue a couple of discovery subpoenas and reset this matter.
You said about how the utilities were paid?
Yes, my understanding is that utilities remained in the tenant's name, that they were paying those regularly until that November hearing of Judge Buchanan. The tenants are now claiming that they were only making the minimum payments and they were paying past due amount. I'm unable to access those records. My clients have called and they've tried to get them, but the utility companies obviously are not going to release an account in someone else's name. So I think that would be an essential piece of evidence in this case. And so I'm asking for the ability to issue subpoenas to Board of Water and Light and Consumers.
That's fine. Is the property secured and winterized?
My clients have gone into the property, Your Honor. I don't know if they have, I would like an order actually confirming the possession that they can retake it because they have gotten a notice from the city that they've asked for an extension until Monday in order to remove trash that's from the property. Otherwise, they're going to get a violation.
So there's trash that you're saying that they left. Can I see?
Yes.
Your Honor, that's something that I'm privy to as well.
Okay, so it's front porch. This is from the code enforcement. They said that there was trash found in boxes, bags, and barrels on front porch, clothing and cloth products on front porch, deteriorated metal product on front porch, loose trash and debris, front porch, in yard, around and behind the house. Did you leave trash at the property?
I guess you could consider it trash, yes.
What are you not hearing? Are you not hearing the video? You might just need to refresh your browser. But I guess if you're not hearing anything, you're not hearing me either. So that's not going to help you. I'm sorry. I don't think anyone else is having the issue though.
There were several items that I explained that I had no choice but to leave behind. I didn't have.
No, you have a choice.
I did not.
You do have a
I had the
choice.
financial ability to do that.
Did you put the trash there?
I'm sorry?
Did you put the trash there?
There were items in the home.
Did you put the items?
interpreting them as
Did
trash
you
is
put
not
the
trash.
items? Did you put the items that have accumulated causing code compliance to come and issue this concern violation about? Did you put it there?
On the porch, no.
So the things there are not yours. How did they get there?
I don't know. They've had the property.
Do you have
since May.
pictures?
I have some pictures of the exterior of the property, yes, Your Honor.
I can't say what they're.
I didn't ask you to speak right now. Do you have copies for him?
I handed him one.
Okay, I see a helmet, I see a, look like child's car, a welcome mat, or something, welcome thing. I don't know what this is.
Again,
I didn't ask you to speak over me.
Oh, I'm sorry.
It looks like something else on the porch. I don't know what it is.
To be boxes and shoes.
You said boxes and what?
It looks to be 2 empty boxes and a pair of shoes.
What are the toys in the front yard?
Those were toys that my children played with outside that I have nowhere to store now. So they were items that were, yes, and left behind.
Okay, so there's shoes, there's boxes. I didn't see debris. You didn't put those there?
I'm sorry?
You saying you didn't put these things there?
That's why I said, is it trash or what are the items so that I can specifically tell you? Like, I wouldn't consider my kids' toys trash, but to each their own opinion.
You left the things here?
Yes, Your Honor.
Then you think that they're supposed to be responsible?
This
for
photo
your-
was taken while we still live there, by the way. That item is in our, that football helmet is currently in our possession. I don't know where these pictures were taken or when, but that time frame they just gave you is wrong. Actually, multiple items that are in these pictures are currently in my possession.
Could I ask him to confirm what date he's going to say that he moved out?
What date did you move out of the property?
It would have been May 30th and 31st.
My
That
client
was the
took these
moving.
photographs at the end of June.
Any other evidence that you have today?
I have a witness with me, Your Honor.
You can take the stand.
Okay.
Oh, we get a
Solemnly
witness.
swear or affirm the testimony you're going to give is the truth
You
and the
got
whole
a
truth under
witness.
penalty of perjury.
I do.
You can have a seat.
Ma'am, can you state your first and last name and spell your last name for the record?
Jennifer Willcutt, WILLCUTT.
And are you a representative of Oak Sparrow Properties?
I am.
Are you employed by Sandy's Property Management?
I was in 2024, yes.
Thank you. And are you familiar with the file for Chase Carson and Amanda
I
Williams?
am.
Have you, and they've lived at 1317 West Shiawassee Street?
Correct.
Have you, since May of 2024, have you been to that property?
Yes,
More than once?
I drove by the property at least once a month from June until November 20th was the last time because I was told that they had told the court they had vacated.
And that's all through 2024?
Yes,
And did you observe any changes in the property between May and November?
yes,
Did items appear to be moved?
yes,
Did it appear to you that there was somebody residing in the home?
yes.
Are you familiar with the vehicle driven by either Chase Carson or Amanda Williams?
I've seen Chase put dog into I think it was a white kind of work type van possibly, or a panel. It was a type of, yes.
So you would recognize their vehicle?
I recognized it on the street, yes. I wouldn't recognize it out in traffic.
Fair enough. When on these occasions that you've described driving by the property, did you observe that vehicle?
Once or twice in the street, yes.
And that was a vehicle that you had seen Mr. Carson access?
Yeah.
At any point in time over the summer of 2024, did you get any notification from the city regarding any unkept lawns?
No.
Was that an indication to you that the lawn had been kept appropriate for the
Yes.
city? I'm sorry? You said something, sir?
Do I need to?
I thought he was interjecting. I'm sorry, Your Honor. Okay. Are you familiar, have you been in contact with the utility company in regards to 1317?
Yes,
And at any point in time, have you received notification that the utilities are being transferred into Oak Sparrow's name?
no.
What is your understanding of the status of the utilities?
On November 20th, 2024, there was no water or electrical service. I called Lansing Board of Water and Light at that time, and they told me that services were turned off on November 18th, 2024. I called Consumers Energy on November 20th, 2024, and they told me that gas service was still in tenant's name as of November 20th, 2024. I later went back to make sure that the property was still secure on December 5th, 2024, at which point there was no gas service. I called Consumers and they said that it had finally been turned off in tenant's name on December 3rd, 2024.
And you said you appeared on the property on November 20th initially, and then
Yes.
again on December 5th. Thank you. How did you gain access to the property on November 20th?
I was told that they had stated that the tenants had stated in court that they had vacated the property, and I was asked by my superior at the time to secure the property. So I asked maintenance to please schedule a time to go over and get the locks open so that we could change locks and secure the property properly. No items were touched or removed.
When you appeared on December 5th, did you notice any differences in the property?
The door was open and it looked like to be some kind of snacks or something on the stairwell and the living room. Things had been moved around a little bit, and that was about it.
Can you just?
Oh, the garage door was also, we had secured the garage door and that had been opened up as well, and it was like items that been moved around in the garage.
The photographs that have been presented to the court for the outside of the property, is that fairly representative of how the interior of the property was kept as well?
The interior has a lot more trash and items left out than the exterior. The exterior is not the worst.
Can you give a general description of the interior of the property?
There's a large mirror in the middle of the kitchen. There's trash bags that the mice have now taken over. There were baby and children's toys in the living room. I think some type of small animal bedding, a bag of animal bedding was in the living room. And then there's just general personal property throughout, clothing items, shoes, children's toys.
Were you able to speak with any of the neighbors who live nearby at 1317?
Yes.
And did they give an indication of observing the Mr. Carson and Ms. Williams there?
It's hearsay.
At any point in time, have either Mr. Carson or Ms. Williams indicated to you or to your knowledge, have they said that they were moving out?
No.
In April, did they indicate that they wanted to renew their lease?
Yeah.
Were you working on actively renewing the lease?
We were actively working on a month-to-month agreement.
What's your objection?
That is not the truth.
Objections are for the evidentiary foundation, not that you dispute what she's saying. So if you dispute what she's saying, when she's finished, I'll give you an opportunity to give your testimony, but that's not an objection.
Okay.
So you can continue, ma'am.
Thank you. Did the
Objection, perjury. Mr. Magoo for the win. Objection, perjury. That's never gonna forget that. Mr. Magoo is awesome. And by awesome, not so much.
I want to call him the Carsons. Did Mr. Carson or Ms. Williams turn in their keys at any point?
No, not to my knowledge.
Did you ever receive any written notification that they were terminating their lease?
No.
Did you actually appear at the property on May 1st of 2024?
I did.
What was the purpose of that appearance?
To inspect the home to see if there was any animal damage and to give animal applications and to explain what paperwork the owners have requested in order for them to stay in the property with their.
And so that was part of a process of extending the lease.
Correct. Mr. Carson also provided me with documentation for the dog licenses and vet records, which I did copy for him and return on May 7th. I did not enter the property on May 7th.
After May 2nd, did Mr. Carson ever indicate to you anything different other than moving forward with renewal of the lease?
No.
Are there any other facts or details that you think would be relevant to the court as far as this matter and whether the Carsons moved out in May?
The picture with the football helmet that was brought up, I took that personally, and that was on June 27th. The trash bin was also at the curb. On November 20th, the trash bin was in the backyard by the garage.
Any other details that you recall of items being moved around or?
There's a small child's car, I believe it's green. When the picture on the front, I think, shows it in front of the stairs, that on November 20th, that was moved into the fence area.
And the helmet's missing.
And the helmet was missing.
And then had the tenants paid any rent between May and November of 2024?
I believe their last payment was May 2024, mid-May.
Do you recall offhand the unpaid balance that's owed to the tenants?
I do.
If I showed you a copy of the ledger, would that refresh your recollection?
Yes, it did.
Go ahead and take a look at that. Don't testify from it, but when you read it, go ahead and look over it. Okay, do you recall the amount that's unpaid rent for the tenants?
$9,900.
Thank you. I don't think I have anything further, Your Honor.
Do you have any questions for this witness?
One second. So you say that you've gone by once a month at least to check on the property.
Yeah.
And you've seen a vehicle that you believe to be mine there, correct?
A few times, yes.
And what was that vehicle?
I think it's a white van or some type of panel that has doors on the back.
Your Honor, I have no white van. I do not own a white van.
Okay,
I've never.
this is
owned
time
a
for
van.
you to give or ask her questions, not time for
Oh,
argument.
okay, sorry. Yeah, that. And are you familiar, you said you were familiar with neighbors then?
I did not say I'm familiar with the neighbors.
Okay, are you aware that they have children there?
I did not.
Okay, and are you aware that children will play with toys if they see them, such as a power wheel left outside that could move a couple times?
Objection
Because
calls for
kids-
speculation.
Just saying that the neighbors next door, they have several.
Your question
children
is
that
it
play with kids'
possible,
toys.
is it possible that the neighbors?
Yeah,
could
is
have-
it possible that someone
That-
else?
No, I'm asking you, was that your question?
Yes, Your Honor.
Okay.
I'm asking, is it possible that someone else may have moved a toy outside the home? That's what your ground you're going on
Objections
for us to be
overruled, you
there?
can answer it.
I guess anything's possible.
Okay. And any of the times that you have drove by the home, did you physically see myself or any member of my family? Okay. And when you called to ask about the utilities, they wouldn't speak to you, correct, about how it works? So it's a good possibility that we were paying the minimums to keep our
Objection,
name from
argument.
getting.
Well, that
And
will
and
cause
speculation.
speculation. That causes speculation. You don't have to answer that.
Okay. Well, my point, Your Honor, is that in order to get something taken out of your name, you have to pay it in full. This came out of nowhere. I had no means to pay it in full. That explains why the utilities were continued to get paid and stayed in our name right up until the point where they just shut them off. It wasn't turned off because we.
I
didn't
understand
want
you,
them.
you've cleared that with me, with the, as part of why you made those payments. They're asking for a continuance so that they can get the records. I'm just getting their testimony now, so when we come back, we don't have to do that.
I understand.
Do you have questions? Any more questions?
Not for her, no.
Okay, thank you. Any redirect?
Why do you believe that Mr. Carson has ownership of a white van?
I have seen him putting 2 dogs in that van on May 1st. About 5 minutes before our agreed upon appointment, where Sandy, Bailey, Bristol, and myself toured the property and spoke with both tenants.
So whether he owned it or not, he certainly had access to it.
He had keys that unlocked and he opened the door and put 2 dogs in.
No further questions.
Did you say you had video or is this what you're talking about?
The video, Your Honor, was taken by another witness who is out of the state at the moment. So if we do come back, I can present that, Your Honor, and have to testify.
Okay, sounds good. I'm going to give you this evidence back for now. You had an issue about the property. You wanted an order?
Thank you, Your Honor. I'd like an order for immediate possession and reserve the money judgment for a continued date.
Well, order for possession is granted. They said they've already turned over possession
That's never been
of
a
the
question.
property. We'll deal with the money judgment. We'll continue for the money judgment issue. Obviously, if they have to clean up trash and debris, that goes towards their money judgment claim. You do understand that, correct?
What's that?
If they have to go into the property to clear out the trash and debris, that costs money. And so that's also evidence that will go towards the money judgment. You
And
understand
now, I don't know if it's possible or anything, but I would have had no problem communicating that with her, that I would be willing to take care of those items and get the property up. to
No,
par,
you,
but
no,
she
you
didn't
just told
answer.
me earlier that you had no choice.
No, I didn't have the
to-
means that within 7 days, but then I can say
No,
I can
but
come back with a truck
It's
when I can
been,
afford
it's
it.
been 6 months since
Yeah,
you
it
said
was
you
they-
left.
Yeah, and I just assumed they wrote it all off. That's why we're here today.
You could know as soon that they
And
filed
I
an
also,
eviction.
go ahead.
They've been on notice of this for several months, Your Honor.
You couldn't have assumed there's been an eviction pending, so you knew that the eviction was still
And is it
pending.
general practice for them to drill out the locks and give themselves back the property without a judgment from the court?
It's not general
Okay,
course,
'cause that has
however,
happened.
it's also not general course of legal property. That's why I asked, was the property secured? And was it winterized? Because if you vacated a property, if I take what you say to be truthful, that you vacated a property in May and that you called one time, no one answered, you left no voicemail, you never followed, do not talk while I'm talking. You left no voicemail, you never followed up. You never got any word to make sure they knew that the property was vacant. That means you left the property exposed and any animal, creature, person could come and take over this unit because you just left it abandoned with things there. When you leave things there, they don't know off the top that you have moved or rendered possession unless you notify them. And this is if I'm taking what you say to be true. And then on top of that, there's still electricity going to this. So if they check the electricity, they see that's still going on. So there's no reason for them to believe that you vacated unless you have communicated to them that you have vacated. It is now the dead of winter. We're in the middle of a snowstorm. It's going to be 0 degrees. That's why I asked, was the property winterized? Because if it wasn't winterized and those pipes freeze and burst and there's damage to the property, and I make a ruling that you have not properly turned over the possession, then now you're responsible for the damage if pipes freeze too. Do you understand how that works? Okay, so what is it that you feel like so urgent that you need to share with me?
I was just wondering, am I the only one that's responsible for communication? If they had any questions, they couldn't have reached out at any point during this? Do they have any attempts to reach out to me or any of my people
No,
to resolve it?
they did reach out to
Other
you.
than court?
They filed a notice to quit and vacate, and then they filed a summons and complaint to bring you to court. They have communicated.
So-
If you have vacated the property, your responsibility is to let them know that you have vacated and turn over the key.
Should they choose not to accept my calls?
You didn't, you testified 1 call. That was your testimony.
Yes, I'm aware.
Already have enough for possession. You didn't turn over.
I'm not questioning.
Yeah, you
possession.
didn't
I'm
turn
just saying they
over,
took it
you
without
did
me
not
saying
turn
so.
over possession reasonably. That's not,
I just was
that's
under
not
the impression they
reasonable.
took it unlawfully.
Well, you left,
There was never a judgment for them to go in and drill out the
you
locks and
mean,
give them
what,
access.
when did they do that?
I have no idea. I
So
have-
how do you know they did that?
Because I went there after our last court date, when I was realized that they thought we were still there.
After the last court date, when you told me you had vacated in May?
Yes, I vacated in May.
So you're saying in May, they drilled out the property and
I
changed the
have
locks?
I have no idea what their time frame for lock drilling was. I
No.
know in November, when
You
I
went in
went there,
November.
the locks were drilled out.
After you've already communicated
When
that
I
you had,
found out that they thought
after
we
you
weren't
had
there.
already communicated that you didn't live there?
Yes. Because
So then
at
what's the
that
issue?
point, they thought the property was still mine.
No,
As
at that
far as
point,
that's
it's the
concerned.
middle of the winter
They're
and you
still
claim you
charging
left.
me for it.
In the middle of the winter, you claim that you left and you left all your stuff there.
No, I didn't claim.
And you said
I
that it's
left in
not your
the winter. I told
responsibility
you
to get it
May,
out.
not the winter.
Judgment for the plaintiff
For possession or money?
and money.
Thank you, Your Honor.
Whoa! They're not even. She's not even going to do a money judgment hearing. I don't even know what they're asking for. I don't think they said it. I'm sure it's on a piece of paper somewhere. Man, I don't know who this female is sitting next to him. I'm guessing it's the mother of his children. I don't know if it's girlfriend or wife, but she has to be looking at this guy like, "What are you doing? What, dude? Stop!" 9K. Yeah. Jeez. Yeesh. Oh, all right. Man. Okay. All right. There's a that was actually a really good time to pause. He's about to say some things as he's walking out. This is actually the part I've seen. But there's only about 30 seconds left of this, guys. So I am gonna end it. I'm gonna end it and just let the rest of it play out. You guys are awesome. Thank you so much for hanging out with me tonight. Thank you for the super chat, Wixom. Thank you for the incredibly generous PayPal. I appreciate it, and I will spoil the crap out of Heather with that. Thank you so much. I appreciate it. And yeah, exactly, Pegleg. And Pegleg, I love the fact that you're here for multiple reasons. You answer my questions almost immediately, and you keep me honest when I say something wrong. I love the fact that you're here, keeping me honest. I'll just keep it at that. So thank you so much. Oh, we need to raid somebody. I was just about to say bye, but I didn't set up for raid, and I don't have enough time to do that after I hit play. I hate that I always have to refresh this when I do this. It should just be ready. It should already be ready. All right, what do we got? What do we got? We have the Jen Hardy. Oh, we're gonna do KCC. Hopefully she's not finished soon. I haven't rated KCC in months, and she's rated me a couple times. So I'm gonna hurry up and end this so we can get a raid over there. She might be ending soon. Lone Wolf he just started about 20 minutes ago, and Jen Hardy is live right now as well. But like I said, I have not rated KCC in probably 6 months, and she's rated me over a dozen times since then. So we're gonna hurry up. You guys are awesome. I will see you guys tomorrow. Until next time, bye.
Can I include standard cost in that?
Absolutely.
Thank you. I'll get that submitted on e-filing.
Can I object? I mean, can I
You can object all you want. I'm done. Thank you.
We weren't even there. They're getting this.
Do you want me to have you escorted out?
Oh,
Excuse me? You want contempt next? Because I can give you 93 days in jail. Thank you. On the record, back on the record.